बिस्मिल्लाहिर्रहमानिर्रहीम। लीगल फोरम में आप सबको खुश आमदीद। Today we are going to discuss Order 9, Appearance and Non-Appearance of the Parties in the Court. Appearance and consequences of non-appearance. How to appear, and if they will not appear, if the parties will not appear in the court, what will be the consequences of their non-appearance. So the rule 1 discuss rule Order 9 of the Order 9, rule 1. Appear on fixed date of the summon. Summon, there's a date mentioned in the summon that you have to appear on that fixed date. So the defendant has to appear on that particular on that specified and fixed date in the court and has to submit his answer in the defense. So you have to appear on the fixed date that is mentioned on the summon. What is rule 2? Rule 2 says if summons cost is not paid by the plaintiff, the suit will be dismissed. If the summons cost is not paid by the plaintiff, the suit will be dismissed because it is a court fee. If you don't pay the court fee, your suit will be dismissed. After that, Rule 3 discusses that if neither party appears in the court, neither the plaintiff nor the defendant appears in the court, then the suit will be also dismissed. If the suit is dismissed in these both situations, then plaintiff can file the fresh suit. Or he will file an application to restore that dismissed suit. Okay, if he gives the reasonable cause to the court to believe that he was late, then there was unavoidable circumstances. That's why he could not appear in the court. That's why he could not pay the fee of the court. So the court will restore his suit. What is the there is a difference between if you file a fresh suit, then again you have to follow the same procedure. You have to pay the fees for the summons. You have to do all that process again from the start. But when you are going to restore the suit, then you have to start just from the summons. Okay, so that's why most of the lawyers, most of the advocates prefer that the plaintiff should restore the suit with and the option, the time fixed for the restoration. For the application of restoration is 30 days. You have to restore your suit within the 30 days after the dismissal. So this was rule number 4. If there was any reasonable cause, then court can allow that application. Rule number 5 says summons returned unserved. Plaintiff given an address which was wrong. Okay, which was wrong. So summons returned unserved. So plaintiff will be directed that you have to file the summons again. Okay, you have to file the fees for the summons again within the 3 months. If he fails to do so, his suit will be dismissed. Rule number 6 tells when plaintiff appears but defendant is not appearing. So there can be 3 possibilities. The first possibility is that someone is served but the defendant is not appearing. The second possibility is that someone not duly served. Okay, someone is not served to the plaintiff, whether he was gone outside the city, outside of his town, or he has gone to the abroad and he couldn't. What is the purpose of summon? To make sure that defendant knows about the case which has been filed against him in the court. It means to bring the knowledge of the case into the defendant's knowledge. Okay, so if the defendant is not served, someone is not served, then second summon will be issued. Okay, then second summon will be issued and the cost will be paid by the plaintiff. The third situation is someone served but not in time. Someone was served but not in time. The process server went to the defendant's address. One of his relative or one of his neighbor told that he has gone outside city for a week. He will return. If he is not returning after a week and the process server is coming again his neighbor is saying that he will come after 2 weeks, and the process server is again coming, and again the the defendant is not in the home, and the date mentioned on the summon has passed, and after that process server again came and he gave that summon to the defendant. Then what will happen? Then someone was served, but the date fixed was not. But someone was served, but not in the time. So that again a next hearing will be given and the chance that hearing will be postponed, and the next date will be fixed for the next hearing. Okay, so this is the when plaintiff appears, but there are three situations. Plaintiff appears, someone served, defendant not appearing, ex parte. Someone not duly served, against someone. Someone served but not in the due time. Then what will happen? The judge will postpone the hearing and will announce or will fix the next date for the hearing. So now here it comes to the defendant. When the defendant appears on the adjourned hearing. Now defendant appears on the adjourned hearing, it means he has been declared as ex parte, and now ex parte proceedings has been started against the defendant. So the defendant comes on the adjourned hearing and he gives our court a reasonable cause to believe that yes, there were few unavoidable circumstances, or the summons were not duly served or were not served in the time. So he will give an application to set aside the ex parte proceedings. He will give application to set aside the ex parte proceedings. So the teacher can ask from you when the defendant will give you the ex parte proceedings to set aside the ex parte proceedings, and when he will give to application to set aside the ex parte decree. Okay. So the decree against him, when the ex parte decree against him is passed, so he will give application to set aside the decree under Rule 13 of the Order 9. Under Order 9, Rule 13, he will give application to set aside the decree. But in the Rule 7, he will give in the application to set aside the ex parte proceedings. Okay, so there is a difference between ex parte proceedings and ex parte decree. So in the ex parte proceedings, he will give application. Okay, and also in the ex parte decree, he will give application for setting aside. Okay, so these are two rules. When the judgment has been, the summons were not, he will come to the court, and when application will be granted, he will give some reasons that summons were not duly served first. Okay, the summons were not duly served, or there were unavoidable circumstances. That's why he could not come. Okay, like there was some conflicts, or some people were becoming the way of hindrance for him to come to the court. So he can give, if he satisfies the court will set aside that proceeding or the decree. Okay, before going forward, I should tell you about the rule number 9. Rule number 9 says plaintiff is barred for fresh suit. Plaintiff is barred by the fresh suit. When plaintiff has filed an application, filed and planned, but he does not appear in the court, only defendant appears in the court. So he is barred by the fresh suit. So what he will do now, he will give an application to restore that suit. He will file an application to restore that suit. He will give this reasonable cause, and the court will believe. If court is satisfied, then court will restore its suit. In these two situations, when the court is restoring the suit or restoring the plant, our court is setting aside the ex parte proceeding or setting aside the ex parte decree, especially setting the ex parte decree. Okay, and when restoring the application. So in these cases, the rule 9(2) says, the rule 9 and sub rule 2 says, the court will provide notice to the defendant that this application was dismissed, the suit was dismissed. Now on the application of the plaintiff, we are restoring this application, we are restoring this suit. So the notice will be served to the defendant in this case. But when the setting aside decree is application is given to the court, so the notice of setting aside decree is given to the plaintiff. Plaintiff will be informed by the notice that yes, there has been an application for setting aside the decree which was passed ex parte against the defendant. So there is an application. So he has to, the court has to give the notice to the plaintiff. So these notices to the defendant in case of application for the restoration, to the plaintiff in case of the setting aside the decree, setting aside the ex parte decree. So these two notices are mandatory for the courts to send to the respective party, to send the particular parties. What is the remedy when the ex parte decree has been passed against you? So what is the remedy? You have two remedies. You can file an application to set aside the decree. Okay, that rule number 13 tells about the decree. Okay, that remedy. And the other remedy is section 96 subsection 2 in the CPC, that you can file an appeal. Both application and appeal can be filed in 30 days. But now, how will you calculate those 30 days? When the defendant gets the knowledge of that yes, the decree has been passed against him. The decree has passed against him. When he gets the knowledge, whether he gets the knowledge after 2 years, whether after 10 years, after 5 years, after 5 months, after 2 days. So he, after the date of that knowledge, okay, after the date of knowledge, he has to file the application in 30 days. He has to file an appeal in 30 days. Okay, when he's knowing, when he's getting knowledge that yes, a decree has been passed against him. So whether he's getting the knowledge after 2 days, after 5 days, after 50 days. So after 50 days, if he is getting the knowledge of that decree, so he will file an application within 30 days. He has to file that application in 30 days, or he has to file an appeal in 30 days. So these are two remedies for the defendant when he has to set aside the decree against the decree which has been passed ex parte. So first he has to file application, otherwise he has to file an appeal. Okay. So these were the compulsory notices. Now come back to section rule 8, that is only defendant appears only when the plaintiff has filed a suit, a plaint, but the plaintiff is not coming. If plaintiff is not coming, only defendant is coming. So if defendant is coming and he is not admitting any claim of the plaintiff, so the suit will be dismissed. The suit will be dismissed. In the first, the plaintiff, the defendant is not admitting any claim of the plaintiff, then the suit is dismissed. Suit will be dismissed. After that, if he admits any claim, any claim, like he says yes, the paragraph number 1, the paragraph number 2, paragraph number 3 are admitted. Yes, the claims of the plaintiffs are right. I admit those claims. So in those paragraphs, the decree will be given in the favor of the plaintiff. Plaint will not be dismissed in this case. Okay, the part the defendant is admitting will be decreed in the favor of the plaintiff. The rest will be dismissed. So this is the procedure when only defendant appears. If he admits the whole claims, the whole plaint will be decided in the favor of the plaintiff. If the defendant admits the part, so the part of the plaint will be decided in the favor of the plaintiff, and the rest will be dismissed. If he does not admit any claim, then the suit will be dismissed. So this was about rule number 8. So now here rule number 10 and 11. In rule number 10 there are several plaintiffs, but in rule number 11 there are several defendants. So only when several plaintiffs are coming, the court will presume that all plaintiffs are coming. Okay, when several defendants are coming, the court will not issue the ex parte decree, but court will proceed with the proceedings of the court. Okay, so this was all about the order 9, appearance and non-appearance. So the teacher can ask from you, the examiner can ask from you, what will be the consequences of the non-appearance when the defendant non-appears. When the defendant is not appearing, there can be 3 possible causes: that he has been summons are served but he's not coming, ex parte decree; the summons are not duly served, against summons; the summons are served but not due in the time. Then what will happen? Then the next hearing will be fixed for the next date will be fixed for the next hearing. Okay, the hearing will be adjourned. Okay, if the defendant is coming and he is satisfying the court that he had hidden knowledge of that particular case, so he will give a reasonable cost. And if court believes if his court is satisfied, then court will set aside that proceedings. He will file an application, and he will also file an application for setting aside decree. And plaintiff has to file an application for the restoration of the plaint or suit. So the notices are given. When the notices are given, these notices are compulsory. And the setting aside decree, there are 2 remedies. One is the application to set aside the decree, and the other is appeal under section 96 subsection 2. If you couldn't come in the time, then you can also file an application under section 5 of the Limitation Act, that is application for condonation of the delay. first of all you have to satisfy the court first, that there were some unavoidable circumstances, that's why you couldn't come. So first this application will be satisfied by the court, then the main application, that is application for the restoration if it is plaintiff, this is for application for setting aside the decree, that will, in the case of defendant. So after that those applications will be decided. The first this application will be decided, okay, the application for condonation of the delay. Okay, after that, if a person is getting knowledge that a decree has been passed against him, he has to file an appeal or application within 30 days. But if a fraudulent decree has been passed against him, he has 3 years time. He can, after the knowledge, he can file an application or file 12(2) application in the section of 12(2), or setting aside decree application or an appeal within 3 years. After that, we will discuss Order 12, and that is admissions. So admissions in the start, I have told you the admission are of 2 types. First is direct, which amounts to the express admission, and the other was indirect, which amounts to the implied admissions. What is direct or express admission? That is consenting statement, that you admit the claims of the plaintiff in the written statement. That's yes, the para of the plaintiff 1 is admitted, the para 2 is admitted, para 3 is admitted. But what is evasive denial? Evasive denial, indirect admission, that you reject any para but without any reason. You reject any claim of the plaintiff but without any reason. That is mentioned in Order 8, Rule 4. Okay, so these are 2 types of admissions. Or the other type of admission is that admitted claims of the plaintiff. When in the first hearing, the court is the plaintiff is defendant is there, but plaintiff is not there. If the defendant is accepting the claims of the plaintiff, so the case will be decided in the favor of the plaintiff. So in all these 3 cases, whether plaintiff is present or not, the decree or the suit will be in the favor of the plaintiff. So when these things are accepted, when these things are made, when the admissions are made, then the plaintiff can give an application for judgment and decree. The plaintiff can give the application for judgment and decree. So Order 8, Rule 4, Order 15, Rule 1, Order 12, Rule 6, they are interconnected with each other. Okay, they are interconnected with each other. So judgment on the admissions, when you have admitted the claims of the plaintiff, the judgment will be given. So the rest of the things are very simple. The notice of the admission, that you will give the notice of admission, that yes, I am admitting. Okay, the documents admitted, yes, these documents which are present in the suit, the plaint, that are admitted. Then there is a form. The forms are given in the Appendix C, or the forms are given in the Appendix C of the CPC. And then there is a notice to admit facts. So if you are admission, first of all there is a general notice of admission, then particularly for the documents, then particularly for the facts. But the notice of the facts you have to give in 9 days before the hearing date. If the hearing is after 9 days, before 9 days you have to file, you have to give the notice of admission of the facts. Okay. After that, if there is a Order 13, that Order 13 is documents, production of documents and return of the documents. First of all, you will produce the documents in the court, then court will, after exhibiting those documents, will return your documents. The court will return your documents within the under the Rule 9 of the Order 13. The documents will be returned to the owner within the under the Rule 9 of the Order 13. Okay, you have to produce the documentary evidence in the first hearing. As the opposite party gets the knowledge that on what point that he has to defend himself, or if he has to defend, and the counsel has to defend his client. Okay. Then there is if you do not produce the documentary evidence in the first hearing, then what will be the effect of that? The effect of that it is a general rule that no document will be accepted later on. No evident documents will be accepted on if you don't produce any document on the first hearing. So if there's an exception, if court permits, yes, the documents should be allowed, then the documents will be allowed which were not produced in the first hearing. Otherwise, those documents will not be admitted in the court as a evidence. The court will reject the documents which are irrelevant. The court will reject the documents which are irrelevant. Then the endorsement of the documents. The court will stamp on the documents which will be endorsed by the court. So those documents are the will be admitted as the evidence. But if they are not if they are not endorsed by the court, they will not be admitted as the evidence. So court will write exhibit. What exhibit means? Original document. So court will write on the document. There's a sheet on the like on the document list, like there's a list. So on that list, court will mention OSR. OSR means original has been seen and it has been returned to the owner. So original has been seen and returned to the owner, that will be endorsed by the court. And whenever you will present that document, that will be admissible as a evidence. So after that, the record of these documents will be kept. The record of these documents will be transferred from the one court on the discretion of the court or by the request of the parties of the suit. So this was the section 13. Since this was the order 13 of the production of the documents. First of all, you will produce the documents. So in these first four rules are very important. And in the end, there's a rule number 9, which is very important. That is the return of the documents. You have to file the application that you need the documents. You need your documents back. So the file and application of the return of the documents is filed under Rule 9 of the Order 13. So this was all about admission in documents. So I'm again repeating that we are discussing the main concepts relating to these orders or relating to the CPC